The immigration landscape in the United States is shifting in ways that many families did not anticipate. And if you have a pending I-130 petition or are planning to sponsor a family member for a green card, the policy changes taking effect in January 2026 under the Trump administration could directly affect your case. What was once a relatively straightforward family reunification process is now subject to heightened scrutiny, new documentation requirements, and processing priorities that favor certain categories over others. If you are not paying close attention to these changes, you could find yourself facing unexpected delays, requests for additional evidence, or in some cases, outright denials that might have been avoidable. I understand that many of you watching this video are already stressed about your family's immigration journey. You have been waiting months or even years for your case to move forward, and now you are hearing conflicting information about what these new policies mean for you. Today, I am going to explain exactly what has changed, who is most affected, and what steps you should be taking right now to protect your family petition. This is not speculation or social media rumors. Everything I am about to share comes directly from official USCIS policy guidance, Department of Homeland Security announcements, and Federal Register publications. Before we get into the specific changes, let me make sure everyone understands what the I-130 petition actually is and why it matters so much. The Form I-130, officially called the Petition for Alien Relative, is the foundation of almost every family-based green card case in the United States. When a U.S. citizen or lawful permanent resident wants to bring a family member to America permanently, the I-130 is the first step. It establishes the qualifying relationship between the petitioner and the beneficiary. Without an approved I-130, there is no path forward for family immigration. Now, here is where the confusion begins for many families. The I-130 approval does not grant a green card by itself. It simply confirms that a valid family relationship exists and places the beneficiary in line for an immigrant visa. Depending on the relationship category and the beneficiary's country of birth, the wait time after I-130 approval can range from immediate processing to over 2 decades. This distinction becomes critically important when we discuss the January 2026 policy changes, because some of these changes affect the I-130 petition stage, while others affect what happens after approval. The Trump administration's approach to family immigration in 2026 represents a continuation and intensification of priorities that were signaled during the campaign and early executive actions. The administration has made clear that employment-based immigration and what they term merit-based categories will receive processing priority, while family-based categories, particularly those involving extended family members, will face increased scrutiny and longer wait times. This is not a rumor or interpretation. This is documented policy guidance that USCIS adjudicators are now following. Let me break down the specific changes that took effect in January 2026. The first major change involves documentation requirements for relationship evidence. Previously, USCIS accepted a relatively standard set of documents to prove family relationships. Birth certificates, marriage certificates, and basic supporting evidence were typically sufficient for straightforward cases. Under the new guidelines, adjudicators are instructed to apply what is being called enhanced verification protocols. This means requesting additional evidence even in cases that would have been approved without issue under previous standards. For parent-child relationships, USCIS is now more frequently requesting DNA evidence, additional witness affidavits, and comprehensive documentation of the relationship history. For spousal petitions, the focus on detecting marriage fraud has intensified significantly, with adjudicators looking for what the guidance calls indicators of non-genuine relationships. This includes scrutiny of financial commingling, communication history, photographs spanning the relationship timeline, and evidence of shared life decisions. If your petition does not proactively address these areas, you are significantly more likely to receive a request for evidence that will delay your case by months. But this is where many petitioners make their first critical mistake. They assume that because their relationship is genuine, they do not need to worry about providing extensive documentation. They submit the minimum required evidence and expect approval. Under the January 2026 guidelines, this approach is no longer sufficient. Even legitimate cases are being held to a higher evidentiary standard, and the burden is on the petitioner to prove the relationship beyond any reasonable question. The second major change involves processing prioritization. USCIS has implemented what they are calling a tiered processing system for family-based petitions. Immediate relative categories, which include spouses, unmarried children under 21, and parents of adult U.S. citizens, remain at the top of the processing priority list. However, even within this category, there are now sub-priorities based on factors that were not previously part of the adjudication framework. Preference categories, which include unmarried adult children of U.S. citizens, spouses, and children of permanent residents, married adult children of U.S. citizens, and siblings of adult U.S. citizens, are experiencing the most significant impact. Processing times for these categories have increased substantially, and the administration has indicated that resources will be directed toward categories they consider higher priority for national interests. What this means practically is that if you have a pending F2A, F2B, F3, or F4 petition, your case is likely to take longer than previous estimates suggested. Now, I want to address something that is causing enormous anxiety in immigrant communities, and I need to be very careful to distinguish between what is actually happening and what is being speculated about online. There have been widespread concerns that the administration plans to eliminate certain family preference categories entirely or impose numerical caps that would effectively freeze processing for years. As of the publication of this video, no such elimination has occurred through official policy or legislation. However, and this is important, the administration has indicated support for legislative proposals that would restructure family immigration categories, and processing slowdowns can achieve similar practical effects even without formal elimination. Let me explain what I mean by that. If a category that previously had a 5-year wait time now has a 12-year wait time due to processing deprioritization, the practical impact on families is devastating, even though the category technically still exists. This is why understanding processing realities, not just legal categories, is so important right now. The third major change involves what USCIS is calling continuous eligibility monitoring. Under previous practice, once an I-130 was filed, the petition remained valid as long as the underlying relationship continued to exist and the petitioner maintained their status. The new guidelines introduce requirements for petitioners to demonstrate ongoing eligibility at multiple points during the extended waiting periods that characterize family preference categories. For U.S. citizen petitioners, this is less impactful because citizenship is permanent. But for lawful permanent resident petitioners, this change is significant. If you are a green card holder who filed an I-130 for your spouse or child, you may be required to demonstrate that you continue to maintain permanent resident status at various points during the processing period. This becomes complicated if you have spent extended time outside the United States, if your green card is approaching expiration, or if there are any questions about your continued eligibility for permanent residence. This is where I need to pause and address something directly. Many families make the mistake of filing an I-130 and then assuming they can simply wait for approval without taking any additional action. Under the 2026 framework, this passive approach creates unnecessary risk. You should be maintaining complete records of your own status, keeping your address updated with USCIS, responding promptly to any correspondence, and proactively monitoring your case status regularly. I will explain exactly how to do this effectively later in the video. The fourth change involves interview requirements and fraud detection. While I-130 petitions filed within the United States have not traditionally required in-person interviews for all cases, the new guidelines expand the categories of cases that will be referred for interviews. If your case involves any factors that USCIS considers potential fraud indicators, an interview is now much more likely. These factors include significant age differences between spouses, previous immigration violations by either party, short relationship timelines before marriage, limited in-person contact history, and financial arrangements that adjudicators consider unusual. If you are called for an I-130 interview, the preparation required is substantial. Both the petitioner and beneficiary, if the beneficiary is in the United States, may be interviewed separately and asked detailed questions about the relationship. Inconsistencies between answers, even minor ones, can raise concerns that lead to additional investigation or denial. Now, let me address who is most affected by these January 2026 changes, because the impact is not uniform across all family immigration cases. If you are a U.S. citizen petitioning for a spouse who is already in the United States with valid status, your case remains in the highest priority category, but you should expect increased documentation requirements and should prepare your petition accordingly. If you are a U.S. citizen petitioning for a spouse who is abroad, you are also in a high priority category, but consular processing times have increased and the scrutiny applied at the visa interview stage has intensified under parallel State Department guidance. If you are a lawful permanent resident petitioning for a spouse or unmarried child, you are in the F2A category, which has historically had relatively short wait times compared to other preference categories. However, this category is experiencing processing slowdowns, and the wait between I-130 approval and visa availability is growing. If you are a U.S. citizen petitioning for a married adult child or sibling, you are in the F3 or F4 categories, which already had wait times measured in decades for many countries. The January 2026 changes are extending these timelines further, and if you have cases pending in these categories, you need to plan accordingly for what may be an extremely long process. If you have a pending I-130 that was filed before the January 2026 changes, you may be wondering whether your case is grandfathered under previous standards. The answer is nuanced. Your filing date is preserved, and you maintain your place in any applicable queue. However, the adjudication of your petition will be conducted under current guidelines, which means the enhanced documentation requirements and increased scrutiny will apply even to previously filed cases. This brings me to guidance on what you should be doing right now if you have a pending I-130 or are planning to file one. First, if you have not already done so, gather comprehensive documentation of your qualifying relationship. Do not wait for USCIS to request additional evidence. Proactively compile birth certificates with apostilles or authentication, marriage certificates, photographs spanning your relationship history, evidence of communication including call logs and message records, evidence of financial commingling including joint accounts and shared expenses, affidavits from family members and friends who can attest to your relationship, and any other documentation that demonstrates the genuine nature of your family connection. Second, ensure your contact information with USCIS is current. Many cases experience problems because petitioners move and do not update their address. USCIS notices sent to outdated addresses can result in missed deadlines and denied petitions. Third, if you are a lawful permanent resident petitioner, carefully monitor your own immigration status. Do not let your green card expire without applying for renewal. Do not take extended trips abroad that could jeopardize your permanent resident status. Your eligibility to serve as a petitioner depends on maintaining your own status. Fourth, check your case status regularly using the USCIS online tools. Do not assume that no news means your case is proceeding normally. Processing delays mean that cases can sit without action for extended periods, and proactive monitoring helps you identify problems early. Fifth, if your case involves any complicating factors, such as previous immigration violations, prior petition denials, or complex relationship circumstances, strongly consider consulting with a qualified immigration attorney who can assess your specific situation and provide guidance tailored to your case. I want to be very clear about something. Nothing in this video constitutes legal advice. I am providing general information about policy changes and their potential impacts. Every immigration case involves unique facts and circumstances, and what applies to one family may be completely different for another. For guidance specific to your situation, you must consult with a licensed immigration attorney. Let me summarize the key points from this video. The January 2026 policy changes under the Trump administration have tightened I-130 family petition requirements through enhanced documentation standards, processing prioritization that favors immediate relatives over preference categories, continuous eligibility monitoring for permanent resident petitioners, and expanded interview requirements with increased fraud scrutiny. If you have a pending petition or are planning to file, proactive preparation is essential. Gather comprehensive evidence of your qualifying relationship before USCIS asks for it. Maintain your own immigration status carefully if you are a permanent resident petitioner. Monitor your case regularly and keep your contact information current with USCIS. The families who will navigate these changes successfully are those who understand the new requirements and prepare accordingly. The families who will struggle are those who assume previous standards still apply or who take a passive approach to their pending cases. If you found this information valuable, please subscribe to this channel for regular updates on U.S. immigration policy changes. We provide accurate, verified information from official government sources to help you make informed decisions about your immigration journey. Coming up in our next video, we will be covering the latest updates on green card processing times and what the February Visa Bulletin reveals about priority date movement for all categories. You will not want to miss that important update. Thank you for watching, and I will see you in the next video.